So I'd like to welcome everybody here to IPI's Zoom briefing on Internet Platform Regulation and Section 230. My name is Tom Giovanetti. I'm the president of the Institute for Policy Innovation. And if you're not familiar with IPI, we are a 33-year-old free market public policy think tank based in Dallas, Texas, with a heavy concentration on technology and innovation issues. I'd like to welcome you all to our briefing today on Internet Platform Regulation and Section 230 with our special guest Jeff Kosseff, author of the book, The 26 Words That Created the Internet. Internet platform liability for speech has become a huge issue. Both conservatives and progressives seem to think that social media platforms are actively discriminating against them and treating them unfairly. And both sides are agitating for Congress to do something. Often doing something means proposals that change the law related to Section 230 and that would make platforms legally liable for third-party content that they either allow or that they choose to block. So this is an important and timely topic. And so we're delighted to have Jeff with us today to talk us through this issue and help us maybe understand it a little better than the common discussion that goes on today. We've asked our friend Bartlett Clellan to moderate today's discussion. Bartlett has a long association with IPI. He's a research fellow with IPI and is himself well-versed on all aspects of technology policy. So we're really delighted to have Bartlett with us today, and he's the perfect person to help guide us through this discussion today. For those of you not yet burned out on Zoom, let me remind you, you can turn your video on and off so you can choose whether or not we can see you or not. You can choose either the gallery or the speaker view up in the upper right-hand corner of the Zoom window. And we will be taking questions by using the raise your hand feature down from the participants menu at the bottom. So if you have a question or comment that you would like to make, go down to the participants menu, click on raise your hand. You will show up in a queue, and we will call on you and unmute your microphones in order, and we'll get to as many questions and comments as possible. Okay. So now with that, I will turn things over to Bartlett Clellan to introduce Jeff and to take us through the discussion today. Bartlett, the floor is yours.
Thank you, Tom. I always love being able to moderate an IPI event. I have been with IPI, I think, since 1999 in one form or another, coming straight off the hill. So right at the end of an era of lots of cool technology policy. But what I most like about IPI is the deliberate, thoughtful, and principled approach. In my mind, one of the few think tanks that actually is consistently thoughtful and tries to push the edge on technology and thinking around all kinds of technology policy topics. So thank you, Tom. I love this opportunity. With that, let me get to introducing Professor Kossoff. Jeff is an assistant professor of cybersecurity law at the U.S. Naval Academy's Cyber Science Department. His latest book, of which I imagine most people who have tuned in have probably heard of the book already, but The 26 Words That Created the Internet, is a history of Section 230 of the Communications Decency Act and was published last year. In 2019, same year, is a very good year, he was named an Andrew Carnegie Fellow by the Carnegie Corporation of New York to support his forthcoming book about the history of anonymous speech in the United States. He is also the author of Cybersecurity Law, which is a textbook and treatise. His research includes more broadly, interests include cybersecurity regulation, online intermediary liability, which makes me think, Jeff, we should have you back again in the future as we start going through the antitrust rounds that we're going to be coming through, and the law of armed conflict as applied to cyberspace, something which I know nothing, so I'd love to attend one of your conversations about that. Jeff practiced cybersecurity, privacy, and First Amendment law at Covington and Burling, and clerked for Judge Milan D. Smith, Jr. of the United States Court of Appeals for the Ninth Circuit, and Judge Leonie M., I'm going to butcher this name, Brinkema, of the United States District Court of the Eastern District of Virginia. He received a JD from Georgetown University Law Center and his bachelor's and M.P.P. from the University of Michigan. I am much admiring of your background and wish I had followed your path, I think. You have done everything that I could imagine doing in the technology policy space, in legal space, which is fantastic. Jeff, with that, I'll turn the floor over to you. I think what we will do is have you speak, then we'll turn to Q&A and remind everyone, as Tom suggested, that you raise your hand for questions. Oh, and one other thing, if you have any reminders turned on your computer, especially when you unmute to speak, if you could have those turned off. They tend to ring clarion on the Zoom technology. That would be great. So with that, Jeff, looking very forward to hearing from you.
Well, thanks so much for having me. And I first, before I start, have to give the disclaimer that everything I say is only on my own behalf. I'm not speaking on behalf of the Naval Academy, Department of Navy, Department of Defense, nobody except myself. And I want to actually I know we're not supposed to ask questions in chat, but I will address the one question that is in chat because it's a really good one. And that is, does Section 230 protect the right for you to mute people and turn off their video? And as with many questions that lawyers will answer, there will be multiple answers. The first answer is yes. Section 230, one thing that's often forgotten about Section 230 is it applies to providers or users of interactive computer services based on someone else's content. So yes, that would apply. But then the caveat that I add is there would have to be a cause of action. And that really gets to a lot of the current debates that we're having today. Is does Section 230 apply? Does Section 230 protect platforms for certain types of claims at a very early stage of litigation? The answer is yes. But then you have to ask the next question: would there have been a claim otherwise? And that's the question that does not often get addressed in these debates. So it's important to look at both of them, and I'm sure we'll talk a lot about that in the next hour. What I want to do is first start off with some history of Section 230, of how we got here, which has fascinated me. I'll say that when I was in private practice, I represented companies, news sites that had hosted user comments. And I became really interested in Section 230 because we would sometimes get complaints, often from businesses that readers wrote a comment about, saying they ripped them off, or a local city council member who was angry about a user comment saying, you've got to take it down. And I soon learned that I could just write a very short letter saying, hey, there's something called Section 230. You don't have a claim against this news organization for user comments. That fascinated me and what I really wanted to look at is, how did we get here that we have, this isn't the First Amendment, this is a statute that Congress passed. And how did we get to this place where Congress passed a statute that lets me do this and lets me say to a powerful member of city council, hey, go away, the Section 230 protects this. And so when I entered academia, that was really the question I was starting to answer. And what I found was that there was very little debate about Section 230 when it was first passed. There was barely any media coverage of Section 230. This law that I do maintain has created the legal environment for many of the largest platforms as we know them today. Was really, some people, the people who wrote it knew what they were doing, but there was very little opposition, in part because it was addressing a very different industry at the time. But it was also very forward thinking, and but there were some consequences that weren't necessarily anticipated. But to understand why Congress passed this, you have to actually go back before the internet. And you have to go and look at what is the liability in a non-Section 230 world, before Section 230 is passed. What is the liability for the distributor of someone else's content? Because that's essentially what platforms are. They're distributing content that their users create. And to understand that, you have to go back to these cases from the 1950s and 1960s, some of which went to the Supreme Court, involving bookstores. And at the time, there were obscenity was defined differently, and so obscenity is not protected by the First Amendment. And so there were some criminal statutes and criminal ordinances that said you can't distribute obscene materials. Los Angeles had one that said if you distribute obscene materials, you go to jail. And even if you don't know that it's obscene, there was no state of mind, no scienter requirement. And so that Los Angeles ordinance goes up to the Supreme Court, and the Supreme Court says, we're going to strike this down because by having effectively a strict liability statute for obscenity, you are going to chill speech, because that's going to cause the bookstore to say, I'm only going to sell books and magazines if I review every single one, and bookstore owners can't do that. So the Supreme Court didn't articulate what state of mind was necessary, but over the next few decades, lower courts did, under the common law and various rulings under the First Amendment, essentially said that if something's defamatory, so this applies to defamation, not just obscenity, defamatory or otherwise illegal, the distributor is liable if the distributor knew or had reason to know of the illegality. And so that worked pretty well for defamation cases, for obscenity cases with bookstores and newsstands. But then we get to the early 1990s, and that's where where some judges start having a little trouble figuring out how to apply this. There was one case where the judge pretty much got it right, and that was in a case against a platform called CompuServe at the time, one of the biggest at the time online service providers, where you could dial up and get it. This was even before the internet. As we know it, this was a closed system where you could go to bulletin boards and forums, and there was a defamatory article in a newsletter that was posted on a forum. And so the person who was the subject of the allegedly defamatory article sues CompuServe. And the court dismisses the case and says CompuServe is pretty much just like a bookstore. And it didn't have reason to know of this alleged defamation, so we're going to dismiss the case. Now, one of the observations the judge made is that CompuServe pretty much doesn't have editorial control. And the judge danced around it a little bit, because really CompuServe could have just declined to transmit the newsletter altogether. So it did, but it didn't have all these user content policies or moderators or anything like that. A few years later, Prodigy gets sued. Prodigy is CompuServe's biggest competitor. Prodigy wanted to distinguish itself as a family-friendly service, so they had a lot of moderators, they had a lot of policies, user content policies, and so they get sued for defamation based on something posted in a user forum. And the judge holds that Prodigy is not a distributor and says, no, Prodigy is a publisher, and makes this common law distinction between publisher and distributor. And what the judge says is, because Prodigy exercises what the judge called editorial control, Prodigy is more like a newspaper than a newsstand. And this is in 1995, and this gets a lot of attention because this is really right at the cusp of the internet becoming commercialized and becoming more widely available. It still is only available to about 40 million people worldwide, but there's a lot of potential. You have schools starting to become equipped, schools and libraries being equipped with internet access. And this ruling gets a lot of attention because what the commentators worry about is, well, does this mean that an online service has to take a hands-off approach, or at least has a strong incentive to take a hands-off approach to otherwise they're going to face just as much liability as the person who posted the content. And that really worries people. At the time, the big concern was these children in schools and libraries accessing legal pornography on the services. And there was Time in Newsweek magazine covers about cyber pornography and this real fear of what impact that this internet is going to have on children. So there's a bill that's introduced in 1995. The Senate attaches it to its version of the first overhaul of telecommunications laws in 60 years. And this provision is called the Communications Decency Act, and it imposes criminal penalties for the transmission of not just obscene, but indecent material. And in the Senate, the senator who proposes it, James Exon, he's very, he carries around a blue binder full of printouts of the pornography that people could access on the internet, and shows it to colleagues. So they passed that. The House has a different approach. The House is probably more younger and maybe a bit more tech savvy. And they say, and they're also concerned about the impact on civil liberties. And they see this as a First Amendment violation, what the Senate did. And this was bipartisan. Speaker Gingrich actually was one of the most outspoken critics of what the Senate was doing. And so Democrat Ron Wyden and a Republican Chris Cox, they propose what's known at the time as the Internet Freedom and Family Empowerment Act. And this is what becomes Section 230. And they say, we're going to address this issue in a different way. We're going to remove the disincentive to moderation. And we're also going to say that we don't want the internet, this new technology that has so much promise, to be overburdened with regulation and litigation. So they propose a bill that says, first, that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So that's trying to address this issue of what Prodigy did, which is set the Prodigy case saying because you took steps to moderate, you're going to be treated as the publisher and you're just as liable as the user. They also include a provision saying the platforms also are not liable if they take good faith efforts to block access to material that the platform believes to be lewd, lascivious, obscene, otherwise objectionable. Of any of the provisions, that probably got more attention. The first provision, the 26 words, I would say there was no floor debate about protecting companies from liability. It just was a non-issue in the debate. There are a few exceptions, one for federal criminal law, one for intellectual property law, which largely becomes copyright, and that gets dealt with the Digital Millennium Copyright Act 2 years later. So basically, as a compromise, both the Senate's CDA and Section 230 end up in the final Telecom Act of '96, even though they kind of conflict with one another. But that ends up not mattering because the next year the Supreme Court strikes down the Senate's version as unconstitutional, as many in the House said it was. So basically, Section 230 really was never proposed as the Communications Decency Act, but it got lumped together with it, and then it ends up being the only part that survives after the Supreme Court is done with it. But what we don't know, and we don't get an answer to for another year, is what does it mean to say that that platforms can't be treated as the publisher or speaker? Does that just mean that they're all treated as distributors, which means effectively that if they know or have reason to know of the illegal content, they become liable? Or does it mean that there is no liability for content someone else has fully created unless an exception applies? A court answers that on the case Zarin versus AOL in 1997, and written by J. Harvey Wilkinson, and he says that this Section 230 is meant to protect speech in a very broad manner, recognizing that the internet is exceptional. And he says that he takes the much broader view of Section 230. And because that was the first federal appellate court, and in the district court, it was the first district court, Judge Ellis in EDBA was the one who initially dismissed the case. That effectively becomes the law of the land. Section 230 has never been ruled on by the Supreme Court, but I would say the Zarin versus AOL case, that is really what has become the interpretation of Section 230. And there have been a few lower courts that have disagreed with it, but they get reversed. So that's where we are now. Section 230 is not absolute. It has the exceptions. We've also had courts that have said, well, the Section 230 only applies to content that is fully created by other parties. If the platform has materially contributed to the creation of the content, then the platform is not protected by Section 230. And you've had that in a number of cases, I would say an increasing number of cases. And part of that is judges have gotten frustrated by this really broad and expansive protection that Section 230 provides. And you can kind of see it, even in the cases where the judges say, yeah, we've got to dismiss the case because of Section 230. They often, not often, but I would say there have been some notable cases where the judges have said, hey, Congress can change this if they want to. And so there has been some a bit of erosion of Section 230. Now I'll say that even with all of the protections that Section 230 was providing to platforms, it generally didn't receive all that much attention for its first 20 years. I mean, in law reviews it did, in some media articles. The Good Wife did an episode of it about it, I think 8 years ago or so, but it really wasn't until I'd say the past 3 or 4 years that Section 230 had been in the spotlight. And I can testify to this because when I was first pitching the book in 2015 and 2016, I will say that there were many publishers who were skeptical about why does Section 230 matter. I fortunately found one that found it interesting enough, but even a few years ago, it was very different. And I think there are a lot of different causes of why Section 230 is so much in the public sphere. I think there have been some very significant cases, some with really heartbreaking results. There also have been a lot of cases of platforms having been arrogant. And even if it's not something directly related to Section 230, Section 230 is an attractive target for the anger at the platforms because it's seen as a protection for the platforms, which they are protected by Section 230, but oftentimes you see debate about Section 230 in areas where Section 230 isn't really the issue that they're angry about. I was just on another panel where they were asking me about cybersecurity regulation and how Section 230 protects platforms from data breaches. And I mean, what's protecting platforms from data breaches is that the United States doesn't have any effective cybersecurity laws. That's not a Section 230 issue, but there are a lot of very legitimate Section 230 issues. And hopefully what I look to do in discussing Section 230 is to sort out what is a Section 230 issue that can and should be addressed, and what is another issue. I'll give one example. Last year, the New York Times, I spoke with the New York Times for about an hour. I was so excited. It was the first time I ever spoke with the New York Times. They were doing an article about Section 230. They quoted about 4 words that I said, which was fine, but what was not fine, it was across the entire front of the business section. And the headline said something to the effect of, why is there so much hate speech online? And they showed a picture of the 26 words from Section 230, and then underneath it, a headline saying, because this law protects it. They had to run a correction later that day saying it's the First Amendment, not Section 230 that protects hate speech. And I would say that captures a lot of what I've experienced over the past year or so talking about Section 230, is that there are a lot of really important Section 230 issues, but there also are a lot of issues that simply are not Section 230. So I think we need to distinguish that. So I think that's about what I had prepared to talk about. I'd really love to be able to get into discussions about Section 230 and any particular issues that anyone wants to discuss.
Thank you so much, Professor. Fantastic background. Really appreciated the history. I was on the Hill during that time, but it's always good to hear the 10,000-foot history, because you're so mired in the what's happening in my office that it's kind of cool to hear all the comings and goings. So I'm going to take the first question here and pick up right at the end of your comments and make it very current. So as we're probably all aware on here, over the last, I don't know how long it's been, 6 months, let's say 3 months, 4 months, there have been lots of various thoughts, I'll be generous, coming out off of the Hill and out of the White House related to Section 230. There have been a variety of proposals, we'll call them, sometimes formally introduced, sometimes off the cuff, or in fact delivered via social media itself. As I understand it, when your book first came out, you were open to amendments to Section 230. But now, given all of the kind of, I don't know, I'll just call it the crazy, do you still think it's safe to talk about amendments to Section 230?
Yeah, I mean, I think it always should be discussed. And I think part of the problem and part of the misunderstandings that we're having now is that it really was not discussed for more than 20 years of existence. I think that part of the problem that we have is that we don't have a really good factual record of what's possible. So, and it's frustrating because there are some people who will say, you know, if you touch Section 230, the internet's going to collapse. There are other people who say get rid of it altogether. My sense is probably the optimal, and I mean, optimal really depends on your own particular views on a lot of different issues. The optimal result is somewhere in between. I testified in the Senate last month about Section 230, and one thing that I've continued to try to push for, and this comes from my other area of research, which is cybersecurity. There was just what I think of an incredibly thoughtful and useful report put out by the Cyberspace Solarium Commission that Congress chartered, and they gathered facts. It was led by experts in the field, really bipartisan and nonpartisan. And I think we need that with platform moderation, because I think that there are many misconceptions about what platforms can do and what they cannot do. And I think a lot of that, we don't have the facts. So I think before committing to, yes, we should do X, Y, and Z, we have to figure out, well, if we did that, what would it look like for all the platforms? Because oftentimes when we talk about the platforms, that's almost a proxy for Twitter, Facebook, and YouTube. And there are a lot of other platforms, and there are companies that I think many people might want to become the next Facebook, Twitter, or YouTube. And how would the changes affect them as well? Because they also benefit from Section 230. And I've been in DC for a pretty long time. I was a journalist covering the Hill, and I can say my skeptical view is that no matter what changes come, it's going to be the big platforms that are more able to comply with them than their competitors. And I might even suggest that the changes could be used in an anti-competitive manner. So I would want to look at those issues as well.
Right, almost always the case, right? We act after the horse is out of the barn, and then what happens is we enshrine that horse, as it were, and no one else can compete. Happens all the time, and in virtually every industry where I've ever seen Congress start poking around and how to fix an industry or in the regulatory side. So one thing you said that I thought was one of the least surprising things you said today was that the New York Times ran a headline saying, "Oh no, online is bad." We know that a lot of the publishers in general have pushed back on Section 230 over time now. This is just something I've played around with. Generally, I tilt towards more liberty, more freedom. What the publishers tend to argue is that we should crank up the government. We should restrict the platforms more than they're restricted now. Do you have any thoughts on what if that went the other way? What if instead of heaping more regulations or more restrictive language or trying to stitch up all the little holes in cases that are either common law or already in legislation, what if we expanded the opportunities for publishers to be under the same guidelines?
So how you mean if a newspaper were to publish its own article online?
Yeah, exactly.
Then, well, I mean, I think that Section 230, first off, Section 230 does apply to a newspaper that operates a website, in that its user comments are protected. I mean, it draws this distinction, recognizing the difference of the internet, in that, I mean, if I were to try to get into the New York Times' pages, for example, or even get a letter to the editor on the New York Times, that's a very different medium where they publish 5 or 10 letters per day. The idea of Section 230 is that there's this vast amount of volume of content, and there's a different liability regime. Now, I'm a former journalist, and I'm all for protections for newspapers from defamation lawsuits. So, I mean, I guess I'm probably the wrong person to be asking about that, because I'd say, sure, get rid of defamation law. But that I think that's probably not going to be a terribly practical outcome.
Alrighty, I see we have at least one question. Tom, I assume you're doing the unmute, or can I do that? But Belen, is that how you pronounce your name? You have a question?
Hi, yes, it's Belen. Thanks for taking my question. I was just curious about what constitutes an act insofar as what makes someone a publisher versus a platform. So I guess the example in my mind is fact checking on Twitter. So would that make them a publisher, or does that make them a platform? And it's just kind of like with moderating, at what point do they become a publisher?
Yeah, so I'm glad you asked that question. So the current debate has really focused on publishers versus platforms, and that's not a distinction in Section 230. So in Section 230, the idea is that you can be a platform that restricts certain types of material or does not restrict certain types of material based on user demand. It's very much a market-based issue without becoming legally considered a publisher. The key is, I mean, the distinction is the real distinction is this information that is developed fully by third parties, or is it information that is partly developed by the platform itself? That's not publisher versus platform. That is basic, just from the definition of what is an information content provider. So the courts, I mean, if there are tools that basically force people to violate the law, for example, there was a case called roommates.com, that's a situation where a platform might not be covered by Section 230, but it's not a publisher versus platform distinction. It's more just, is this information that's provided by another information content provider?
So I have something related to that, and then I see Steve Del Bianco has his hand up, so we'll get to you, friend, in 1 second. But so along those lines, where you had mentioned that that at some point when platforms are involved in creating or modifying language, et cetera, at some point they might trip into participation. So what have the courts said about that? And you mentioned some of the judges got fed up with the breadth of the law. Is there any consistency in where that line is getting drawn? Or are we already getting into a world where it's getting increasingly difficult to understand where you might draw that line?
Well, I want to be clear that modifying, where generally the courts would say Section 230 didn't apply is if the modification itself, and this really depends, it's fact specific. Let's say that so a user posted a comment saying, I really dislike this member of the city council, and then on a newspaper website, and then the newspaper editor posted a comment underneath saying, yeah, I think he committed murder or something like that, and he didn't. That wouldn't be that would not be protected by Section 230, because that's the newspaper is actually having the defamation. But if there were 10 comments that all users posted about the city council member alleging he committed various crimes, and the newspaper deleted 8 of them but kept 2 up, that would not, they would not lose Section 230 protection for the decision to not take down those 2 comments. Okay,
so newspapers are certainly, in that example, the publishers certainly understand where their protection might lie and can take advantage of it.
Yeah.
Okay, great. So Steve, a longtime friend, over to you.
Hey, thank you, Bartlett. Steve Del Bianco with NetChoice. Hey, Jeff, really enjoyed your book and following the way in which you're contributing to this debate. So it's a hypothetical question, but without Section 230, with this tool we're using today, Zoom, would this tool be liable for defamation that came from my lips, or I shared a screen with defamatory information, would Zoom be sued? And without 230, could they be held liable? Thank you.
Well, so that's a good question. And we don't know for sure, because we don't know exactly how the common law and First Amendment protections would have played out for a platform like Zoom. Whether it, I think that the Prodigy case, for example, I think the courts probably would have ended up overruling that. And then if Zoom were to be considered a distributor, what would it mean for Zoom to have a reason to know? So we don't know for sure, but what we do know is that Section 230, without Section 230, a lot of that about did Zoom have a reason to know about the defamation, that would have to likely go through discovery and be decided at summary judgment or a trial. When Section 230, many Section 230 cases are decided at the motion to dismiss stage, which is very early on. So I think that even if ultimately Zoom were found to not be liable in a defamation case, there's a very good chance that it would have to go through some pretty extraordinary legal expenses to get to that point.
And those extra expenses would have affected the design and operation of tools like Zoom. Mm-hmm. That after a few of those cases and spending a few $100,000 on defending itself, they may have to change the way this product works.
Yes.
That even if somebody was admitted with a password, and Bartlett and Tom cleared everybody on this call, how is Zoom going to allow real-time interaction if it exposes them to liability? And I think you're right. You're right about emphasizing that the person who committed the defamation, me in this hypothetical, I am always open to be sued by the people I defamed. The only question would be, how can we insulate technology tools from those expenses of having to defend themselves in court? Thank you.
All righty, scanning. Dr. Matthews, you have a question? Wait to be unmuted.
There
you
Thank
go.
you, Bartlett. Jeff, for several years, I was a contributor to Forbes.com. And their model was you self-publish. You go online, you put your piece in, you do the editing yourself. No editor sees it, you just post it. And then if a question comes in, then those of us who are doing the pieces, we would have to go through the questions. If there's bad language, we had to change it. If it was a racist comment, you just delete it or else change it to take that part out. So it was always going through the person who wrote the piece for both the content and to approve the questions. I'm now a contributor at The Hill, in which I have an outside editor there at The Hill that goes through this. And any questions that come, any comments that come through, I see I don't have anything to do with them. They post them, and I'm completely oblivious to what's happening there. Is one of those platforms more protected than the other? Is there a reason for a publisher, for a Forbes to say, this is a better way to go to protect ourselves than The Hill, or have things just transition, whereas The Hill is fine and the Forbes is fine and it doesn't make any difference?
Well, so with the caveat, this is not legal advice to any any media outlet. It really is fact specific, and it also, frankly, is going to be judge specific. One of the very earliest Section 230 cases was a case where Sidney Blumenthal sued AOL based on a Matt Drudge. Really a very damaging allegation that Matt Drudge made about him. And the court, and this was a case where AOL had this marketing and distribution arrangement with Drudge, and the judge found that Section 230 did protect AOL in that circumstance. So it really does get very specific about the facts, about what is the role of the company and what are they doing with the content. But we've had a lot of cases where recently, I'd say in the past 5 years, where judges have really pushed back against that holding and said, no, we're going to find enough involvement with the platform that that the platform itself is an information content provider.
So are you saying you really under current circumstances, you really can't say one approach is better or more protected than the other?
I mean, I hesitate to. I would say that it's probably the have the users post it themselves is more likely to be protected, but I would not guarantee anything one way or the other right now.
Well, I have an answer for you, Dr. Matthews, along those lines. Which is better? It's the one that has more personal accountability built into it. But that has nothing to do with the legal side. That has to do with the philosophical. So I'm now shifting my seat this way because Tom is to this direction of me here on the screen. But if I know Tom, after all of these years working together, he's chomping at the bit to get a question in here. So Tom, let me just turn to you.
Tom is chomping at the bits. That's absolutely the case. Jeff, I have some sort of high-level questions for you that are related to the current debate and the current churn that goes on related to Section 230. There seems to be a misunderstanding among a lot of the critics of Section 230 that if the platforms moderate, somehow they should be required to give up their liability protection. And I think your explanation of the history that this was all related to the Communications Decency Act, and this was all related to giving the platforms the ability to actually police their platforms. I just want to sort of draw a strong connection between those two. The whole part of the idea of Section 230 was to allow platforms to moderate without losing liability protection. Isn't that right?
Yeah, I mean, I think that's exactly right. The Section 230 really is very much a market-based law. It says, you know, a platform can choose to do a whole lot of moderation or very little moderation, and the users will effectively go to whatever meets their needs. And it's not both the platforms and the users. So that's one thing that often is forgotten. I mean, at the time of Section 230, one thing that Congress explicitly said it wanted to protect was the ability of these online services to offer tools like NetNanny and SurfWatch, which let parents have settings that blocked children from accessing certain things. But they also recognize, you know, we might want the platforms themselves to delete garbage. And if there's too much garbage, people aren't going to want it. But if people start getting all of their posts deleted, that also might not be attractive. So it's this idea that the platforms are better positioned both practically as well as legally to make these choices about content, as opposed to either the federal a regulatory agency or the federal court system.
That's really terrific. And that sort of leads me to my next question, which is a lot of the critics of internet platforms, and I'm thinking of like Senator Hawley and people like that part of their solution seems to be to force platforms to be exposed to greater liability risk when they moderate, when they delete content, or when they allow content, or whatever they do. And it strikes me that the logical outcome of a move like that is actually to a situation, you know, however you perceive the current social media environment. I mean, I know there are people out there that think the world would be better off if social media didn't exist. I understand that. But however imperfect it is today, it seems to me that if we expose the platforms to greater liability, we would end up in a place that is worse than where we are today. It strikes me that we would either end up in a place where platforms did not moderate at all, in which you would end up with this sort of Wild West situation where you would have horrible content and pornography and all kinds of stuff that would be present on the platforms. Or you would end up in the exact opposite situation where the platforms decided they had to double and triple down on moderation, and you had more and more content that was blocked and that was excluded because it was controversial. So, you know, it may be that what we have today is imperfect, but it may still be the best possible world. What do you think about that?
Yeah, I agree. I think that we don't completely know how the platforms would respond, which is, again, why I keep asking everyone who will listen about this commission to figure out what would the responses be and what is possible. But I think that the only other outcome could be there might be fewer outlets that give users the opportunity to post their own content. So again, I'm of the mindset that I think Twitter and Facebook will figure out how to shape the rules so they'll be able to live with them. But if you're a small community forum or something like that, or a small newspaper website, and many newspaper websites have decided not to allow user comments altogether, which is their prerogative. But you might be less likely to allow user content because you're just saying, well, I don't want to take the risk. And even if it is something that's First Amendment protected, which it often is, without Section 230, that still might mean that we're going to have to go through a lot of litigation. And so that would be one other obstacle, I think.
I'll make one more comment, and then I'll remind folks that if you want to ask a question, go down to the participants menu, choose the raise my hand option, and we still have some time to get to a few more questions. Jeff, the point you made early in your presentation and then just now, that there are other platforms other than Twitter and YouTube and Facebook, I think is really important, because so many times in policy we see this happen where someone decides to craft a law to go after a specific, perceived bad guy or a specific perceived problem. And you have all these unintended consequences that cascade from there. You talked about the New York Times earlier. The New York Times, if they allow comments, they are both a publisher and a platform, right? They are liable for what they choose to publish, but yet Section 230 still protects them for the user-generated content that they allow, but don't necessarily choose to publish. So it seems like if we're writing legislation that's designed to, target, Twitter moderation or something like that, there's grave danger to all of these other platforms that exist they're not in the target, but they would be affected by all of the unintended consequences.
Yeah, and I think there's also, I agree, I think there's also the constitutional issue in that even if you were to condition Section 230 protections on moderating in a certain way, that raises its own First Amendment concerns. What the courts have held is that if a law that directly required a certain type of act would violate the First Amendment, conditioning a government benefit, which Section 230 is, on that same behavior is what's known as an unconstitutional condition. So that could raise a lot of, in addition to the practical concerns you mentioned, there are some significant constitutional issues as well.
We do have a question from Rob. I'm going to interject. Actually, I have a ton of things I'd love to chat about, but the one that strikes me going right off the tail of this conversation is, I find it always interesting in policy making, particularly when the legislators are involved, is the private sector involvement. And there's no doubt in my mind that publishers have gone in a particular direction, that is to limit comments. And I just think that speaks to something very broad about what we could imagine in a world without Section 230, and that is that there's less opportunity for me or for Tom or for anybody here or anyone in the country to be able to express their opinion as they would have it expressed, understanding that there's still plenty of laws in place that if they defame, et cetera, other folks, that they will be held accountable. It almost appears to come in, and I don't know any publishers, have not had a long conversation with them to know this for sure, but it seems it almost comes down to the business decision of, if I can get rid of these folks as competition and, oh, by the way, have trial lawyers chase after them and sue them out of existence because of some perceived slight, then I can go ahead and I can continue to push my narrative of how I would like the world to be, from whatever publication that is, in a constant way without the competition of truly everybody's speech. And I do remember back in the mid-90s when we were on the Hill, and I'm sure conversation was happening everywhere. It was happening there, though, about how wonderful this new invention was, how cool it was going to be that all citizens could voice their interest or their objection or their support in a way that could never be done before, because we did filter through big government, big media, big something else, and that we finally had an opportunity to have our own voice. So I just had to add that, because Tom, you mentioned that, yes, of course, publishers still can allow comments. Professor, you mentioned how a bunch of them have started limiting those, and I see that all the time. And it just seems to me that that is the truth of where things will go. So I'm going to assert that without allowing any other comments, because I am right. So I don't want anyone to disagree with me. And we will go to the question from Rob. Rob, are you unmuted?
Yes, I'm unmuted now. Thanks, Bartlett. Talking about constitutionality, Professor, I kind of wanted to hit on whether you think the executive order put forward by President Trump is constitutional. You know, and seeing as there are, I think, some getting frustrated with Congress, you know, strong supporters of 230 reform or of eliminating it entirely, who are growing tired of congressional efforts not going where they want them to. Is executive action possible? Is it smart? And any other thoughts you have on the executive order would be interesting too.
I'm gonna, because even though I'm speaking in my personal capacity, I do work for the federal government, so I'm gonna refrain on giving any specific thoughts on any specific proposals. But I think that looking at how the law can be interpreted, I think that's fine. I think that it's just, the question becomes, what have the courts said, and how do you interpret that? But I think that in terms of the constitutionality, I think that I think looking at how to interpret it, and I mean, agencies can give guidance, at least as long as Chevron still exists. But I think that in terms of how courts apply it, that's a different question.
Okay, thank you.
And thank you, Rob, for that. We have 4 minutes left. So a couple of things I want to do to make sure we get to them. So first of all, I know that everyone should go out and buy your book, Jeff, if they haven't already.
Sure.
I assume it's available at
Amazon,
everywhere. Fantastic. Number two, I've got to figure out a way to get into one of your cybersecurity talks, because I'd love to learn more about your particular.
Well, just enroll at the Naval Academy.
Very good. I will show up there tomorrow, wandering around. That'll be fantastic. I'm sure I qualify. Let's see, what else? If people have more questions or want to learn more on this topic, where would you recommend they go, or how do they get in touch with you?
Yeah, I mean, I'm on the internet. Just Google me and my email address. Feel free to reach out. But yeah, I would say to learn more about it, obviously read my book. To learn about the sort of day-to-day developments, I would highly recommend Eric Goldman, a professor at Santa Clara University. He has a blog that I would say it's not documented every case in Section 230's history, but most of the hundreds of cases are documented in detail there. So yeah, I mean, but yeah, feel free to reach out to me with any questions. I love talking about Section 230. Fantastic.
And so with that, I'll thank everyone, but I want to turn it back over to Tom to wrap up. So thank you, Professor. It was great having you.
Thanks.
I hope we get to have you back, maybe as this debate develops and continues, and we meet some interesting junction in Section 230 in Capitol Hill. Tom?
Thank you, Bartlett. And I should also mention that Jeff is also very active on Twitter, or at least you have been recently. I know you start teaching classes in a few days, don't you?
Yeah, 2 days.
Yeah, so you actually get back to your day job.
Yes.
Here in a couple of days. We really appreciate you joining us. Jeff is a great follow on Twitter if you're interested in these topics. And I should also mention that we will be archiving this video on our website. So if you think this has been an interesting discussion and you want to share it with some people that you know, feel free to do so. It'll be available in just a couple of days on our website. And Jeff, we would love to have you back at some point, maybe to talk about some other issues, especially related to cybersecurity, because that's, I don't know if it's fair enough to describe that as an emerging issue or a front burner issue these days, but I know it's one everybody's concerned about. So let me just thank everyone for joining us. Thank you, Bartlett, for moderating. Thank you, Jeff, for carving out some time for us. And we've been doing these Zoom policy briefings every couple months or every couple weeks all throughout the pandemic season as a way of staying engaged with issues and with our audience, and we'll continue to do so. So check back on IPI's website to see when our next scheduled event is. And with that, I will bid you everyone a good afternoon, and thanks again for joining us.